Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, a partner at the Immigration, Medical Malpractice, and Business Litigation law firm Kurzban, Tetzeli & Pratt, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Serenade e-Immigration. If your caseload is growing, you've probably felt this. At some point, more cases start to mean more chaos or more hiring. But it doesn't have to work that way. There's a really good guide on immigration case management that shows how better systems and workflows can actually increase your capacity without just adding more people. It covers everything from data consistency to client communication. And it's totally free for Immigration Review podcast listeners. Get this and tons of other free resources at get.eMigration.com/IRP or click on the special link in the show notes. This podcast is also sponsored by Gonzalez & Gonzalez Immigration Bonds. Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez take it from there. In business and family-owned for 75 years, Gonzalez & Gonzalez helps other families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process and typically get refunds within 1 to 2 weeks of receiving the I-391 notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your clients stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2% plus $40, and for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They've got those too. Give Gonzalez & Gonzalez a call, check them out at immigrationbond.com, or click on their special link in the show notes. And as always, this show does not constitute legal advice and is intended to keep you up to date and enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Summer is upon us. And this week, in the summer, among other things, a district court judge barred USCIS from its policy of not adjudicating applications from people from certain countries just because they're from that country. Good on you, district court. Blanket labeling of people because of where they're from should never be the policy. On the cases, I'm doing 10 decisions this week. It is not letting up. The summer is usually pretty busy, but this summer has been exceptional. So much so that I now have to push the Third Circuit decision in Laureano v. Attorney General of the United States to a future week again for the second week in a row. I will do the decision, folks, but I need to catch my breath. In that vein of overwork, and because it's a bit tangential to what I normally do, I must mention, this week the Seventh Circuit also held that it lacked jurisdiction or similar stuff to review a U.S. citizen petitioner's challenge to USCIS's determination under the Adam Walsh Act that the petitioner failed to establish that he or she poses no risk to the beneficiary that they seek to petition for. Those in the know what I'm talking about, but Adam Walsh Act challenges continue to be very, very difficult. And with that said, getting that Seventh Circuit decision out of the way, here are your 10. 10! Kicking it off with Alvarado-Paz v. Blanche, published by the Fourth Circuit on June 1st, 2026. This case about asylum. Miss Alvarado-Paz and her minor child are from El Salvador and fled to the United States in 2016 after her father, Fabian, threatened to kill her. He's been abusing the whole family her entire life. Heck, Fabian once killed his stepfather with a machete. Fabian was terrible to Miss Alvarado-Paz's mother as well, his wife, but it was Miss Alvarado-Paz's foster brother who murdered the mother. My God. Miss Alvarado-Paz accused her father Fabian of being behind it, though. Seems like the motive might have been about an inheritance. The other siblings agreed with her. Miss Alvarado-Paz's minor child witnessed the murder, the derivative respondent in these proceedings. Law enforcement in El Salvador took no action. Quote, about 2 weeks after the mother's death, Miss Alvarado-Paz was approached by 2 unknown masked men as she was traveling to visit her mother's grave. The men threatened to kill her if she continued investigating her mother's death. End quote. For various reasons, she believed them connected to her father and fled the United States. She asserted a variety of female and familial type particular social groups in immigration court and testified credibly. Related political opinions as well. The basis for denial was on nexus mostly, although there are many pages documenting the substance of the IJ's denial. Convention Against Torture was denied too, and the BIA affirmed it all. Fourth Circuit sent it back. First, the Fourth Circuit agreed with Miss Alvarado-Paz that the BIA erred in holding that she only asserted 2 of her 4 particular social groups on appeal to the BIA, and so refused to consider them. That's not correct. She asserted them before the immigration judge too, so the BIA had to consider them. Those 2 added groups were Salvadoran women and family members of witnesses to crime. And just the BIA was flat out wrong about it. Those particular social groups were raised below. Oil conceded this but argued that it didn't matter. Oil is wrong, explains the Fourth Circuit. Quote, we start from the premise that an error of this kind generally requires remand, end quote. This, even though the BIA said what it so often says, that it was adopting the IJ's decision, and then said some other stuff too. I like this articulation, quote, because the BIA didn't believe that the IJ had considered the particular social group, Salvadoran women, at all, it would be illogical to read the BIA's decision as adopting and affirming anything the IJ had to say about that claim, end quote. Other stuff too, although it doesn't look like Oil's even arguing the recent BIA stuff that the BIA published in an effort to kill gender-based asylum claims. So that's something. And obviously the Fourth Circuit sees it as potentially viable, that is, Salvadoran women as a particular social group, else it would have deemed the error harmless, no? Just saying. The Fourth Circuit does not believe that the case, however, for the other particular social group, family members of witnesses to crime. The court believes Ms. Alvarado-Paz herself helped create this confusion by referring to the group in a few different ways in her briefing, and you can't do that. You can't refer to one group multiple ways and then assert on appeal that actually you meant multiple groups. You can, and maybe should, assert multiple groups with different iterations due to the Fourth Circuit having affirmed matter of WYC and HOB, but you can't refer to one in multiple ways and then try to assert the multiple iterations on appeal. You follow? Essentially explains the Fourth Circuit. The court also affirmed the denial of the rule of law type political opinion-based claims. Quote, none of Ms. Alvarado-Paz's arguments contradict the core problem identified by the IJ. Her advocacy on this political issue was limited to promoting justice for her mother's killers, end quote. Similarly, on the other particular social group-based claims, the Fourth Circuit affirmed their denial as well. Turning to the Convention Against Torture, well, the Fourth Circuit believed that at base, Ms. Alvarado-Paz was asking the court to reassess the record evidence and reach the opposite conclusion. The court can kind of do that after Nasrallah, kind of, but it's substantial evidence review, not de novo, and that means that the IJ and the BIA have to be quite wrong to get reversed. Unmet here. For example, quote, the BIA and IJ specifically considered and rejected Ms. Alvarado-Paz's argument that how the Salvadoran authorities responded to her mother's murder demonstrated that they would acquiesce in torture to her upon her return, end quote. And the Fourth Circuit believes that the BIA's decision supported by the record. But a remand it remains, potentially on a very important particular social group issue, and so. Congratulations, Brendan Halvar Eckern-Connors and Zachary P. Ludgren from Holland and Knight for petitioners. And that is Alvarado-Paz v. Blanche. Not done with the Fourth Circuit. Next is Uddin v. Blanche, published by the Fourth on June 5th, 2026. This case is about crimes of child abuse. Not a wonderful fact pattern, but here we go. Mr. Uddin is from Bangladesh, is a Canadian citizen, and is a lawful permanent resident of the United States. But in 2019, he pled guilty to one count of having violated New Jersey statute annotated section 2C:24-4 B5A III. That is, that he, quote, knowingly stored or maintained 25 or more items depicting the sexual exploitation or abuse of a child, using a file-sharing program, which was designated as available for searching by or copying to one or more other computers, end quote. And now he's a sex offender. Convicted in 2019, but the offense occurred in 2017. DHS alleged that this made him removable because it's a crime of child abuse, neglect, or abandonment as defined in INA Section 237A2EI, and all courts have now agreed. A couple of interesting questions to begin with, though, the first being, which version of state law governs when the statute at the time of the conduct differs from the statute at the time of the conviction? Uber important here because the 2018 edition, which I guess was the applicable statute when Mr. Uddin was convicted, added elements that makes the conviction broader than this child abuse removable offense. The Fourth Circuit doesn't explain why that is, but that's a huge deal. But again, the conduct alleged in the indictment all occurred in the fall of 2017. But he was indicted and, of course, convicted after the amendment. Interesting legal issue. Well, explains the Fourth Circuit, it looks at the statute at the time of the conduct, not the conviction. And that is a holding with significant implications beyond this case, both potentially good and potentially bad for non-citizens. Quote, a judgment of guilt rests on the law as it stood when the defendant acted. The ex post facto clause permits nothing else, end quote. That is of the U.S. Constitution. Apparently, this rule aligns with decisions out of the 3rd, 11th, and 10th Circuits and an unpublished decision out of the 9th Circuit, footnotes the 4th Circuit. So let's look at those 2017 elements and the INA child abuse removability definition. Quote, to be a categorical match under the INA, New Jersey's law must meet 3 elements. 1, an act or omission that causes harm or creates a reasonable probability of harm. 2, to a child. And 3, a culpable mens rea as to the conduct at issue, not the child's age, end quote. This New Jersey statute, in turn, makes it a crime to, quote, knowingly store or maintain an item depicting the sexual exploitation or abuse of a child, using a file-sharing program which is designated as available for searching or by copying to one or more other computers, end quote. And New Jersey law defines child as a person under the age of 18, and the Fourth Circuit gets rid of the whole Escobar-Quintana 16 versus 18-year-old thing because that's only statutory rape and there's prior Fourth Circuit precedent. Not getting into all that, but it does hit it up in a footnote, and there you go. So the disputed element here is harm, whether the minimum conduct creates a reasonable probability of harm to a child. It does, explains the court. Without saying it, it seems the Fourth Circuit believes the statute a categorical match, thereby permitting Mr. Uddin to avoid removability if he can satisfy the realistic probability test. And he came up with some hypothetical ways to do it that would not necessarily cause harm to a child, it seems. The problem to the court is that it doesn't believe such crimes actually covered by the New Jersey statute. Quote, the statutory offense is not mere possession or private storage, end quote, which I guess might not constitute sufficient child abuse harm. Rather, quote, New Jersey courts have applied the statute exclusively to dedicated peer-to-peer file-sharing programs, end quote. End quote, circulation is the harm, end quote. It inflicts ongoing injury to the child depicted. Supreme Court has said this many times, explains the Fourth Circuit. The victim is actually harmed at least 3 times by the creation of the materials, then when the materials are permanently put in the record in the public sphere, and then renewed harm every time that it's circulated, explains the court. And that could be many, many, many times. The statute also doesn't apply to merely minor-to-minor private exchanges. The file-sharing element is about public use, reasons the Fourth Circuit. Now, apparently the statute also criminalizes AI or altered images of children. So no initial harm to the child there, right? Just a regular picture of a child altered. But, quote, manipulation of non-explicit images of real children fares no better. Even where the child was not physically harmed during production, morphed images implicate the interests of real children and create real victims by their production, end quote. Again, it's the sharing that's really doing the harm. And straight AI images that don't have any involvement with any real child, those aren't covered by the statute. It has to be a real initial image of a child, later altered to qualify for a conviction, explains the Fourth Circuit. Having held all that, the court held that it lacked jurisdiction to review the denial of LPR cancellation of removal, as Mr. Uddin didn't present a viable legal challenge, and the Patel decision with the Supreme Court destroys factual challenges to the denial of such relief. To be fair to Mr. Uddin's attorney, it does seem that he tried to bring a legal challenge, but the Fourth Circuit doesn't believe them actual legal challenges, or, if legal, viable ones. Meaning Mr. Uddin is removed to Canada, I guess. And that is Uddin v. Blanche. All right, you know what time it is. BIA Hellscape. This week's edition. Starting off with matter of NAGC, published by the BIA at the beginning of the week. In the face of a massive circuit split and 4 circuits and counting disagreeing with it, the BIA has doubled down on matter of Hurtado and mandatory detention. And I'm not going to lie, there was just so much this week that I had completely forgotten about this one by the time it was time to record. The life of a case law podcaster. This decision is only good law in the 2 circuits that have affirmed Hurtado's rationale, and the 5 that have not yet spoken as of this recording. And the decision only has a year at most on the books, unless the inevitable Supreme Court decision next term comes out in favor of the Hurtado reading of mandatory detention. Anyway, here's the decision for the next year in some circuits. Mr. NAGC was a child when he entered the United States and was designated an unaccompanied minor such that he should be on a path to adjust to lawful permanent resident status. No criminal record is mentioned by the BIA. Nevertheless, removal proceedings began in 2023. Then in September 2025, in what surely appears to be little more than that White House policy to terrorize non-citizens for policy reasons and financial gain, Mr. NAGC was detained by ICE, as were so many at the time. That is, summer and fall 2025. An immigration judge granted his request for a bond hearing and ordered his release on a $4,000 bond. For reasons that make no sense to me, an ICE attorney decided to appeal that. His client, after all, is what we in the business call a nightmare client. We've all had one. ICE Opal's client is quite powerful, and no less demanding than many these days. The BIA has sustained the appeal. And although Mr. NAGC entered without authorization as a child, quote, the immigration judge concluded that the BIA's decision in a matter of Hurtado did not control because the respondent had previously been designated an unaccompanied minor child upon entering the United States in 2022 at the age of 17 and has an approved Form I-360 petition as a special immigrant juvenile, SIJ, end quote. The BIA does not like this effort by the IJ to disrupt its attempted mandatory detention, Goliath. Matter of Hurtado controls, explains the BIA. Unless and until the Ninth Circuit rules on the issue favorably for bond eligibility, possibly in this very case where jurisdiction is. We'll see what happens. With almost no legal citations, the BIA states, quote, detention authority for applicants for admission is governed by Section 235B of the I&A, which does not authorize IJs to consider bond for such non-citizens. Section 236A of the I&A governs a different statutory category and does not apply where Congress has prescribed detention rules for applicants for admission under Section 235, end quote. To be honest, to me, it seems like the BIA is using this decision a bit to fight back at some of the logic used by the circuits that have since rejected matter of Hurtado. Everyone's speaking to the Supreme Court at this point. More important to the issue at hand, the BIA explains that the SIJ stuff doesn't change anything. I don't do unaccompanied minor children cases and SIJ stuff, I admit, but it seems that the argument is you can't mandatorily detain an unaccompanied minor child. Many reasons for that, both legally and morally. So the BIA explains that Mr. NAGC was no longer a child when he was detained, and so his unaccompanied designation doesn't govern the detention inquiry. Having recently reinterpreted the law that Congress wrote after 30 years, the BIA then explains, quote, Congress has not provided that a prior UAC designation confers bond jurisdiction on an IJ, and a court may not create such authority by implication, end quote. Sorry, it's hard to get that out without smiling. Now, apparently multiple district courts have held otherwise, and counsel for Mr. NAGC relied on them. The BIA is, quote, not persuaded, end quote. Seems like some of the rationale by those district courts is that UAC designation permits adjustment of status, which of course is true, but explains the BIA that's not because a UAC designation is an admission. Nor does it create an exception to the BIA's new interpretation of the statute in Hurtado, which the BIA discusses and repeatedly relies upon in this decision as the only possible interpretation of the statute. The BIA also states, quote, "We find no validity to the IJ's reasoning that the respondent's prior UAC designation renders him exempt from a variety of grounds for removal or by the IJ's reliance on Loper-Bright to provide a basis for custody redetermination authority in these circumstances," end quote. The BIA provides a bit of a non sequitur and explains that, quote, "Immigration proceedings are civil in nature," end quote, and that civil detention is no big deal and totes constitutional. And so it's not really discussed what's going on here. I imagine the IJ provided this reasoning that is about the fact that the UAC designation renders him exempt from some removability grounds and citing to Loper-Bright to explain that Mr. NAGC isn't really a flight risk, to explain why mandatory detention may be punitive here, and to explain why a matter of Hurtado may not hold up in the Ninth Circuit. Maybe all three and more. I don't know. The BIA doesn't discuss it. Laying on its new interpretation of Hurtado after nearly 30 years real thick, the BIA concludes that, quote, "Where Congress has mandated detention and omitted bond authority, we may not supply jurisdiction by implication," end quote. As such, this young man with no discussed criminal history and what appears to be a decent path to a green card, if given the time, will be returned to immigration prison at something like $250 a day to U.S. taxpayers, which of course is the least of the harms caused by human incarceration without individualized justification. Gonna lighten it up a bit, but also, I'm quite serious about this, too. The BIA concludes by writing, quote, "DHS's appeal is sustained," end quote. Writing that DHS apostrophe without a second S after DHS. All right, guys, let's do it, folks. Isn't that wrong? Shouldn't the possessive use of DHS include a small s after the apostrophe? Isn't the rule that you add an s to a noun when making it possessive, even if the word ends with an s, unless the noun itself is plural? So like the phrase, "octopus's garden" doesn't get a second s, where said garden houses multiple octopuses. But the same phrase would get a second s if there was only one octopus tending to the various flowers, fruits, and fauna of said garden. Caveat that octopuses is spelled octopuses, while the singular is spelled octopus. But the ending s point remains. One octopus who owns a garden is spelled octopus apostrophe s. Now, if that grammatical rule is correct, there are multiple problems with leaving out an s here. First off, DHS is an acronym. And even if somehow the grammatical rule requires a modified categorical analysis of an acronym, the word security doesn't even end with an S. And DHS, of course, isn't referring to multiple DHSs. So it should be DHS's appeal is sustained, DHS apostrophe S, which it shouldn't have been sustained anyway, but that is entirely a different issue. I personally run into this grammatical problem when the United States becomes possessive in my brief, like the United States' argument. Sub-issue here, really. Assuming the rule I just discussed is correct, United States still gets the apostrophe S, right? Because while states, of course, refers to multiple states, some would even say 50, the proper noun United States is singular. Can't wait to get all the emails about this one. And no, the most proper plural of octopus is octopuses, not octopi. I looked it up. Don't email me about it. And that is a matter of NAGC, and a lot off my chest. Moving on to Matter of Mills, published by the BIA. This is a decision about discretion that did not used to be precedential, but the acting attorney general decided to make it precedential. Let's see if he stops acting one of these days. Looks like he's about to be nominated. Mr. Mills is from Canada and was granted LPR cancellation of removal by an immigration judge. The BIA overturned that on DHS's appeal. DHS apostrophe S, written by Kevin Gregg. No hardship required of that relief. Just need to be an LPR, have the requisite years, not have an aggravated felony, and deserve it as a matter of discretion. Also, BIA case law would hold that you have to have obtained LPR status lawfully. As I mentioned, it's the discretion thing that the BIA has beef with. LPR, Mr. Mills would almost surely not be seeking LPR cancellation of removal if he didn't have a criminal history that made him removable, right? Restated, nearly all applicants for LPR cancellation of removal have a criminal history, I'd think. And the statute was very clear that Congress really only has an express problem with aggravated felony convictions. The BIA has been on a campaign, however, to make discretion the exception that swallows the rule, and this is another decision in that vein. Quote, we acknowledge, as did the immigration judge, that the respondent presented numerous equities. The respondent is 60 years old and has several health issues. He's been a lawful permanent resident for over 30 years. He has close relationships with his son, daughter-in-law, and grandchild who reside in the United States. The respondent also maintained steady employment and consistently filed his tax returns in the U.S. End quote. He also has, however, quote, 2 separate convictions for criminal possession of stolen property and burglary in 2000, a conviction for endangering the welfare of a child in 2004, a conviction for driving while ability impaired in 2007, and a conviction for harassment in 2024, end quote. The BIA particularly doesn't like the 2007 conviction because he got in an accident that caused physical damage, looks like while he was drunk. The BIA relays that the Supreme Court has held that such conduct is, quote, an extremely serious crime, end quote, that is DUI. In addition, explains the BIA, 22 years ago, he was convicted of endangering the welfare of a child. Quote, he testified that the incident involved his babysitter and confirmed that he was initially charged with sexual abuse in the 3rd degree, though the conviction was limited to endangering the welfare of a child, end quote. The BIA is going to go behind the record of a conviction all day on discretion these days, folks. Plus, in 2024, he had an altercation with his ex-girlfriend that the BIA also believes is serious, looking behind the actual conviction. Quote, immigration law considers crimes against persons to be particularly grave, end quote. To the BIA, the 2024 event severely undermines a rehabilitation argument. Saying multiple times how much it does not minimize the significance of the family ties, extensive long-term residence, and other positive factors in this case, the BIA ordered Mr. Mills removed to Canada. And that is Matter of Mills. Moving on to Matter of JOA, published by the BIA. This case is about particularly serious crimes and lots of acronyms. Outrageously complicated issue that is particularly serious crimes. The BIA made precedential the issue in a case litigated by a pro se respondent. It comes to the BIA, though, on remand from the Third Circuit, and neither Mr. JOA nor DHS filed briefs on remand. The BIA ruled against pro se Mr. JOA. He is a lawful permanent resident, and in 2017 was convicted of healthcare fraud in violation of 18 U.S.C. Section 1347. He's from Nigeria and applied for asylum and related relief and protection. An IJ denied it all, finding the crime a particularly serious one that precluded everything except cat deferral, and then denied cat deferral. Oil and Mr. JOA, likely through counsel, requested remand primarily in light of the Third Circuit's decision in Luziga v. Attorney General of the United States. That was a 2019 decision. And apparently at the BIA, it has remained ever since. Kind of a theme this week and last week, right? Long pending BIA decisions that the BIA is now getting around to and making bad law for non-citizens in the process. Also kind of a theme of the Biden-era BIA to let things linger and provide openings that are now being exploited by the Trump-era BIA. Now, first off, in a footnote without analysis, the BIA holds that the conviction is an aggravated felony. That makes it a per se bar to asylum. No analysis and doesn't even say which aggravated felony, though given the IJ's ruling, it's safe to assume that it's I&A Section 101A43M, a fraud or deceit crime involving victim loss of over $10,000. No analysis or citation, but I guess that's precedent now. Whether it bars Mr. JOA from withholding of removal, though, requires application of the matter of NAM analysis, because Mr. JOA did not receive an aggregate imprisonment sentence of at least 5 years. It's not a violent crime, of course, but, quote, we have repeatedly held that although offenses against persons are more likely to be categorized as particularly serious crimes, crimes against property may also be found to be particularly serious, end quote. A relatively recent phenomenon, though, BIA, if you're being honest. It being an aggravated felony makes it more likely to be particularly serious, explains the BIA. Now, I'm not going to lie. I don't see this as the most non-citizen adverse decision ever, or even this week. It was beginning to get just a little bit murky whether the BIA thought it needed to conduct an elements-based approach at the first step of matter of NAM. This decision, though, makes clear that it must, quote, the first step of this inquiry requires analysis of the elements of the offense, end quote. in fairness relaying the Third Circuit's instructions. The BIA conducts that analysis and holds that all subsections of the crime inherently involve deceitful or fraudulent conduct. But then the BIA goes wild, stating, quote, thus, regardless, the statutory elements bring the offense within the ambit of particularly serious crime, end quote. So the BIA is very much holding that all fraud or deceit crimes are of the type that are particularly serious. They all satisfy matter of NAM Step 1, it seems. News to me, but matter of FRA is quite the rough one for non-citizens in this vein, episode 93, and relied on by the BIA here. Kind of the same analysis used for CIMTs though too, right? Fraud or deceit is a CIMT. But just because something's a CIMT, of course, doesn't make it a particularly serious crime. Seems like the BIA is blurring things a little bit. That's just step 1 of matter of NAM. Are the elements of the type to make it particularly serious? The BIA explains further why this crime is of that type. It's healthcare fraud, where the victim must be a, quote, healthcare benefit program, end quote. And, quote, as the victim must be one that provides healthcare benefits, items, or services, it logically follows that any fraud inflicted on such a plan or contract may well negatively impact or affect the entity's ability to continue providing healthcare benefits, items, or services, end quote. Individuals convicted of this statute include those who defraud Medicare recipients, usually older and vulnerable populations, explains the BIA, although unsure if that's what Mr. JOA did. Quote, fraud in all its forms is a blight on our society. Victims of fraud, from the U.S. government to insurance companies to everyday individuals, face significant financial and emotional harm, end quote. Couldn't agree more, BIA. Just a bit of a weird look having Donald Trump's BIA say it, though. Like, kind of weird. The man's been fighting fraud allegations his entire life, it seems. So explains the BIA, particularly serious crimes need not be crimes against persons, and fraud crimes almost always satisfy the first NAM element. That holding then allows the BIA to look at the circumstances of the crime and really everything else. $2.65 million monetary loss in this case, so that's significant, plus nearly a 1-year imprisonment, 3-year probation, and $1.5 million restitution. That therefore supports the IJ's finding that Mr. JOA was more than a minor player in the scheme, which by implication supports a non-particularly serious crime finding for minor players for another day. Quote, while the respondent ultimately cooperated with the government, this does not impact the finding that he was convicted of a particularly serious crime, end quote. As such, that leaves cat deferral, and apparently no one requested remand for updates, meaning the BIA assumes that facts in this case are from the time of the IJ's decision many years ago. Apparently, unknown men in Nigeria have been looking for Mr. JOA and threatening his family, and he fears he'll be kidnapped. Seems maybe it's because he's a successful businessman in Nigeria, as told by the BIA. But in this case, quote, given the absence of any direct encounters with the criminals, the respondent fears insufficient evidence that his relative or employees have been targets of kidnapping and the respondent's ability to relocate within Nigeria, the IJ permissibly found that it is not more likely than not that the respondent will be tortured, end quote. Mr. JOA's reliance on general crime doesn't change that finding. So too with government acquiescence. Seems like a main argument involved police doing nothing when the nephew's home was robbed, but actually, apparently, quote, a notorious kidnapper had been arrested and convicted, end quote. To the IJ, the Nigerian government does prosecute crime like this, and the BIA agrees that the evidence supports that finding. Sometimes ineffective, but that's not acquiescence, explains the BIA. And for all those reasons, Mr. JOA lost his long-pending case. And that is a matter of JOA. Rounding out this week's edition of the BIA is Trying to Kill Me, we have an 11-page decision on social distinction, published Friday afternoon by the BIA. Matter of SEMZ. It vacates an IJ's grant of withholding of removal. In an appeal that has been pending, it appears since April 2019. April 2019. Was it timely? Who knows? What a world. It's an MS-13 recruitment and family-based case from Honduras. I'm sure the BIA doesn't like the claim for multiple reasons, but this decision will attack and narrow the social distinction requirement for a proposed particular social group to be viable. Daughter kidnapped, nephew murdered. Terrifying existence, it seems, being sent back to Honduras 10 years later and 7 years after the IJ's grant. It's a family-based particular social group, so we're talking matter of LEA 1 and 2, the second of which Attorney General Bondi brought back to life before losing her job. And quote, in matter of LEA the second, the Attorney General held that an applicant's immediate family generally will not be distinct on a societal scale, whether or not it attracts the attention of criminals who seek to exploit that family relationship in the service of their crimes. End quote. Need to kind of be a special family in the given society. Multiple circuits have disagreed. Some have agreed. The BIA pushes on. Now, quote, in determining that the applicant established a valid family-based particular social group, the IJ found that people within Honduran neighborhoods know each other and are highly familiar with the details of families within those neighborhoods, end quote. Assuming it's true, not good enough to the BIA. The inquiry has to be of society at large. Although recognition locally, I guess, is relevant, maybe a little bit. Pages and pages to the BIA why this is, surely speaking to future circuits that will be reviewing this decision and this rule. That is, that social distinction has to happen on a nationwide scale and not locally. Talking to the circuits because this is, after all, kind of an advisory opinion, but it does bind IJs in most circuits. Whether a social distinction finding is permitted based on local or neighborhood distinction is a question of law, left to the circuits without deference post Loper Bright. To the BIA, though, quote, in asylum and withholding of removal claims, consideration of a particular social group designation is constricted to the applicant's relevant society and the past harm experienced and prospective harm feared therein. This reference to society must be viewed within its statutory context of nationwide persecution, which is a fundamental aspect of fear-based relief. End quote. The regs support this too, explains the BIA. And the BIA string cites circuits that it believes support this rule. To the extent that the BIA has used more claim-friendly language in the past, that's not what the BIA meant, explains the BIA. So social distinction of the family-based group was unmet in this case. The BIA also reversed on nexus. To satisfy nexus to the BIA, quote, the protected ground 1 must be a but-for cause of the wrongdoer's act, and 2 must play more than a minor role. In other words, it cannot be incidental or tangential to another reason for the act, end quote. That first element isn't always the law in some circuits, and the second element gets a little mushy in some places. The BIA string cites decisions that it believes support these rules, and footnotes a slightly contrary Third Circuit decision on the second element, and then acknowledges that its rule here, especially the first element, the but-for-cause nexus thing, is at odds with Fourth Circuit precedent. But this case does not arise in the Fourth Circuit. In this case, the IJ, quote, found that the gangs initially targeted the applicant's daughter for recruitment, but then targeted the applicant because she was the mother of that daughter, end quote. That doesn't cut it, quote. Even if the family ties provide a but-for causation for harm to the applicant, the goals of recruitment and sustaining the gang's power and control are the only central reasons for harm in this case, end quote. Strong words. Plus, the expert testified that gangs will do anything to anyone who disobeys or threatens their power and control. And the murder of a nephew isn't the immediate family anyway, right? Explains the BIA. And yes, this is in the Fifth Circuit, so the IJ was wrong to rely on non-citizen-friendly Fourth Circuit precedent like Hernandez-Avalos v. Lynch, 784, Fed 3rd, 944, Fourth Circuit, 2015. Notes the BIA. Technically remanding the case, the BIA took away the IJ's grant of withholding of removal. And that is a matter of SEMZ. You didn't go to law school to enter data. I know I didn't. Yet here you are. H-1B season in full swing, and your team is buried in beneficiary forms, document chasing, and data entry. That's $400 an hour in legal talent doing $20 an hour work. Staffy plugs directly into your workflow. Staffy handles the data entry, document collection, and H-1B form prep. Your team reviews it, you approve it, you bill. With the new wage-weighted selection process adding even more admin pressure this season, the firms that scale are the ones that stop doing it all themselves. Say yes to more H-1B clients without burning out your team. Visit staffy.cc or call 786-891-5619 or click on the special link in the show notes. Because you deserve a practice that grows without burning you out. Welcome back. And there will be more non-citizen good in this episode. But first, we got to get through some rough. Perez Castillo v. Blanche, published by the 7th Circuit on June 1st, 2026. Horror show of a decision. This case is about attorney sanctions for the use of AI fake case law citations and the removal of a longtime habitant of this country. The latter being Mr. Perez Castillo, who was brought to this country as an infant. He left at some point and re-entered unlawfully in 2002. He then developed a rap sheet. He beat up his family while drunk, so that's bad, and he got 18 months of supervised release, which he violated and spent time in jail for. In removal proceedings, he applied for non-LPR cancellation of removal, but an immigration judge denied, deeming the conviction a crime of domestic violence under I&N Section 237A2EI. If true, that bars him from relief per the statute. And the conviction is battery under Illinois Law 720 ILCS 5/12-3A1. Nor did the IJ see sufficient hardship to Mr. Perez Castillo's U.S. citizen spouse in the alternative. The BI affirmed on the conviction thing and held that Mr. Perez Castillo waived a challenge to the alternative hardship finding, which, if true, is a poor appellate decision that is surely about to prove fatal before the 7th Circuit, where he petitioned for review. Before getting there, in a footnote, the 7th Circuit reads the Supreme Court's Oriana decision as requiring a substantial evidence review of fact-intensive mixed questions of law and fact, like hardship review post-Wilkinson. I called it! Even though Oriana was about past persecution, taking a victory lap. Although I wish I didn't have that victory. And then, yes, right off the bat, the 7th Circuit holds that, quote, waiver alone requires us to deny his petition, end quote. That is, of the denial of non-LPR cancellation of removal. In the alternative, the 7th Circuit sees nothing in the record to overturn the hardship finding. Quote, removal will always cause hardship for a spouse or family member. The mitigating factors in this case, including the ready availability of family support, indicate that Mr. Perez Castillo's wife faces no exceptional and extremely unusual hardship. End quote. Also, the 7th Circuit believes that Illinois battery, where the victim is a parent or sibling, as is the case here, qualifies as an immigration crime of domestic violence. Not so difficult to find, as apparently the 7th Circuit has repeatedly held that the conviction is a crime of violence, at least in the sentence enhancement cases. Being a crime of violence is the first element required of the crime of domestic violence inquiry, that is, that it meets the elements of a straight crime of violence. With the second element being that the victim, quote, is protected from the individual's act under the domestic or family violence laws of Illinois, end quote. I guess that's the second element of the Illinois offense. Siblings and parents meet that element, and while the 7th Circuit doesn't say it, I believe that second prong of the analysis is subject to a circumstance-specific approach. So Mr. Perez Castillo's conviction meets the immigration crime of domestic violence. The victim was a domestic person, and the elements meet the crime of violence definition. All of that analysis did not take many pages of this decision. The next 14 pages are probably why the case is precedential. These attorneys effed up. Mr. Perez Castillo's attorneys included fake case citations in the brief to the 7th Circuit. Quote, moreover, nearly every quotation in the brief could not be traced to a real opinion. Hallmarks of AI hallucinations, end quote. Really bad, folks. Also, the attorney messed up facts and didn't file a reply brief, although considering all this, that astonishingly appears a minor issue. Looks like AI might have even hallucinated the facts of the record. Not going to get into specifics, it is a rough read. When the 7th Circuit figured this out, they issued an order to show cause and required the attorney to come explain himself at oral argument, which is just so bad. Not sure if the explanation is any better. In response, the attorney, quote, informed us that he had outsourced the research and preparation of the brief to another attorney, a member of the Illinois Bar. In fact, the first attorney conceded that he had no input in the research and preparation of the brief and fully believed that it was in compliance with all court rules, orders, and rules of ethics, end quote. The first attorney claimed that the contracting attorney told him that she used AI, quote, for the limited purpose of stylistic and grammatical review. But she did not do a final and complete line-by-line verification of quotations and citations, end quote. And I'm not saying the attorney names because, well, that's just not what I do. Then the actual attorney of record was required to file a corrected brief by the 7th Circuit, which he did, but it still had material errors. I don't know, folks. If you're the attorney hired by a non-citizen, the buck stops with you. The contracting attorney messed up huge here, but the buck stops with the hired attorney who puts their name on things. Those are just my thoughts. Seventh Circuit too, though, it sanctioned both of them. Kind of. The first attorney admitted that he didn't even review the brief he filed. That attorney said at oral argument, quote, "I assume when an attorney has put themselves out there as an attorney that writes briefs, that they're following the rules. And I didn't believe that it was on me to read you the brief for someone who's writing briefs as an attorney," end quote. I mean, maybe. But also then even more for the attorney who actually submits the thing in court and signs their name, explains the Seventh Circuit. As to the contract attorney, she, through counsel, admitted that she used ChatGPT to write the thing, but denied doing it for the legal research portion. She included a bit of a cryptic sentence on that legal research thing that neither I nor the Seventh Circuit fully understands. The attorney blamed ChatGPT for changing what she wrote during what was supposed to be a grammar and spelling check on the brief she wrote. That's her story. The Seventh Circuit does see the contract attorney's response as, quote, apologetic. Expressing her regret for these mistakes, she accepts responsibility for not checking the brief after using ChatGPT, and she assures us this will not happen again. She also committed to attending Illinois' minimum continuing legal education course on the risks, benefits, and ethical considerations of using AI. Noting that she is a new attorney who has worked as a solo practitioner since 2025, she asks us to discharge the order to show cause without imposing sanction, end quote. Not every problematic use of AI is sanctionable, explains the Seventh Circuit, but this one is. It's an egregious use of AI. Further, quote, the attorney who signed the brief admitted to violating the court's rules of professional conduct, but did not take responsibility or apologize. The author of the brief has shown contrition, yet she has not provided a fully satisfying explanation for these errors, end quote. And then the first attorney compounded his error with that second submission that still had errors, right? The court goes on for many, many pages in more detail, but I'm not really going to do it all, and I've been talking long enough. No one needs to know the rationale because listeners of the Immigration Review podcast should be striving for their life to avoid any sniff of ever making this mistake, whether they ultimately are sanctioned or not. The representing attorney received a Rule 46 sanction of $5,000 and a warning if he does it again, he's probably going to get disbarred by the Seventh Circuit. As to the contracting attorney, she's not actually admitted to the Seventh Circuit. The Seventh Circuit can still sanction her, but declined to do so. It officially admonished her, though. Quote, attorneys must ensure that their work product does not contain false legal citations or factual errors, whether they enter an appearance in the case or not, end quote. And then the Seventh Circuit referred the whole thing to the Illinois bar. In no small part because it, the court, still has questions about how all this happened. Yikes. And that's it for now, because the Seventh Circuit is actually still keeping it all alive vis-a-vis those two attorneys to see what happens with the Illinois bar's investigation. Absolute nightmare. And that is Perez Castillo v. Blanche. If that wasn't bad enough, I've got to do it again. Next is Lunu et al. V. Blanche, published by the Ninth Circuit on June 3rd, 2026. The Seventh Circuit isn't the only circuit sanctioning immigration attorneys for using AI this week. Really bad stuff, but it is plaguing all bars and even some judges right now, certainly not limited to immigration. I'm going to get through this decision much quicker. It's a 30-page decision that actually doesn't discuss the non-citizens case at all. Looks like the attorneys here denied AI use when the Ninth Circuit believes they clearly used AI. The court uses this decision, quote, as a warning to the members of this court's bar. Be aware of the risks of over-reliance on generative AI. Read everything cited in a court filing, whether drafted by generative AI or not, and disclose quickly and transparently generative AI hallucinations that are inadvertently included in court filings, end quote. Seems here that the attorney cited fake cases with real quotes from other cases, and then, after the case was ripe before the Ninth Circuit, sought to replace those cases through an errata sheet by replacing the cases with real cases whose names sound like the fake cases, but that have nothing to do with the propositions cited, or I guess the quotations. That's a bad look if I'm understanding what's happening correctly. And like the Seventh Circuit decision, the person who actually wrote the brief was a contract person. But unlike the Seventh Circuit decision, that person wasn't even licensed to practice law. But yet counsel admitted, quote, that no licensed attorney read the cases cited by the unlicensed brief writer, end quote. That, my friends, is bad news bears. And the main attorney in this case did it in other petitions for review too, the panel investigation came to conclude. Ultimately, the attorneys came to concede that it was likely an AI job, and they took action to correct the other case filings too. The court discusses generative AI in detail and the ethical obligations of attorneys, and also takes pains to mention that here we've got multiple types of ethical and AI violations, as well as multiple instances and a bit of an attempted cover-up job. The buck stops with the attorney who signed the documents and filed them in court, always. Gotta review it, folks. Gotta read all the cases cited in a brief, too, explains the Ninth Circuit. Both the attorney who signed the briefs and who is the managing attorney of the law firm, and the attorney who presented oral argument and wasn't completely honest at oral argument, it seems, were fined $2,500, were suspended from Ninth Circuit practice for 6 months, were ordered to provide this devastating order to every judge in state or federal court currently pending where they appear, must provide a statement in all future filings about their AI use in that filing, and affirming that they personally reviewed all cases in the filing. And additionally, they're going to have to go deal with the California bar. Yeesh. May this be the last time I do a case like this on the podcast. And that is the new et al. V. Blanche. Tenth Circuit decision, Bonilla-Espinoza v. Blanche, published by the 10th on June 1st, 2026. This decision is about motions to reopen. The 10th Circuit dismissed the appeal in chief on episode 301. Recall, that decision was about nexus, imputed gang membership, exhaustion, due process, and IJ's failure to develop the record, translation issues, and El Salvador's state of exception. This motion to reopen brings the same claims, but purportedly new evidence as well. Quote, the motion attached a 16-page affidavit that included details of his political opinions, his and his mother's political activity in El Salvador, the abuse he suffered while detained, and his partner's detention. Also attached were expert reports and other evidence of country conditions in El Salvador, end quote. Importantly, however, it does not appear to be based on changed country conditions. Motions that can be brought at any time if they make the non-citizen now eligible for asylum or related relief and protection. Instead, this seems to be the same claim, but with more and new facts and details. Explains the court, motions like that must be brought within 90 days of the BIA's dismissal of an appeal, if an appeal is taken, and this motion to reopen was brought nearly 6 months after the BIA's order became final. It's pro bono counsel, and counsel argued that the BIA should equitably toll the 90-day deadline just a few months, because after all, it looks like he was pro se, that is, Mr. Bonilla-Espinoza. In support, Mr. Bonilla-Espinoza, quote, contended that he had proceeded diligently both before and after retaining counsel. He had never stopped searching for counsel. He was allowed to speak with counsel for only 1 hour per day from the detention center. I guess that's prior counsel. And he was not eligible to file a motion to reopen until he obtained his new evidence, end quote. And I don't know, maybe it's later counsel, whatever. Pretty hard to build a case from detention. If that's not the point of detention, it's certainly known by ICE and those coordinating policy in D.C. The BIA denied the request for equitable tolling. Not diligent enough. Quote, his general assertions that he faced resource constraints while detained and was not eligible to file a motion to reopen until he obtained the new evidence he now submits were not sufficient to show that he acted diligently and that an extraordinary circumstance prevented him from proceeding during the time before he filed his motion to reopen, end quote. Alternatively, the BIA didn't believe that the evidence was new and previously unavailable anyway, but here the 10th Circuit affirmed on that first thing, the equitable tolling. Motions to reopen are disfavored after all, so the 10th Circuit takes its abuse of discretion review seriously, explains the court. As an initial matter, the 10th Circuit rejected Mr. Bonilla-Espinoza's argument that the BIA's decision was not reasoned enough for review. It was. From how the BIA analyzed things to the court, quote, it is apparent that the BIA understood and considered petitioner's arguments, end quote. That is all that's required for the BIA's decision to be reasoned enough. On to the substance of equitable tolling, then, Mr. Bonilla-Espinoza argued, among other things, that, quote, despite his best efforts, he could not obtain counsel until November 2024. During the time he proceeded pro se, he advanced his case diligently, even though he doesn't have a high school diploma or speak English. He was further burdened because, as set forth in the affidavit submitted to the BIA, he had limited access to the law library, computers, and telephones, hampering his ability to gather evidence and prepare his motion to reopen, end quote. And that was just the beginning. There was much, much more. Again, based on the struggles of being detained But the 10th Circuit agrees that Mr. Bonilla-Espinosa's relevant statements in his affidavit are too conclusory on the specifics to paint the timeline needed for equitable tolling. And apparently neither the affidavit nor brief actually reference specific efforts to find counsel from the time of Mr. Bonilla-Espinosa's detention in February 2023 all the way to October 2024 when the motion to reopen date expired. Other parts of the affidavit relevant for diligence are short on specifics too, to the court. Not only that, but the 10th Circuit appears to agree that much of the affidavit wasn't new evidence anyway, except for one part. Quote, one could question whether it is due diligence to devote weeks preparing an affidavit devoted largely to material that would not be relevant to a motion to reopen. End quote. Yeesh. Really going at it now, the 10th Circuit explains that in addition to failing to establish diligence, the motion to reopen failed to establish the other equitable tolling requirement, that something extraordinary stood in the way of filing. Lack of counsel and resources, common in removal proceedings, explains the court. Plus, Mr. Bonilla-Espinosa managed to get around that when he timely filed his notice of appeal, and his appeal with the BIA, notes the court. As such, the motion to reopen denial was affirmed by the 10th Circuit. And that is Bonilla-Espinosa v. Blanche. We've reached the end with Muchiri v. Blanche, published by the First Circuit on June 3rd, 2026. His case is about asylum and stuff. Mr. Muchiri is from Kenya, overstayed his visa, and applied for asylum in immigration court. In its oral decision denying asylum to Mr. Muchiri, the IJ found that Mr. Muchiri was credible and had successfully established that he had suffered past persecution on account of family. The IJ based that finding on evidence that he put forward to show that while in Kenya, he suffered abuse at the hands of his father, who is a, quote, Mungiki, which is described throughout the record as a movement, cult, tribe, gang, clan, and minority religion, end quote. The IJ further found, however, that the government had overcome the presumption of a well-founded fear of future persecution based on evidence that showed that Mr. Muchiri is an adult who is no longer subject to his father's control, and country conditions in Kenya have changed, such that police are now making an effort, quote, to combat the Mungiki group, end quote. And yes, indeed, that is how asylum works. DHS can rebut the presumption of future persecution, even where past persecution is shown, based on a showing of a fundamental change in country conditions. But even where that occurs, there's the lesser argued form of humanitarian asylum. To qualify, the applicant must show either, quote, compelling reasons for being unwilling or unable to return to the country arising out of the severity of the past persecution, or a reasonable possibility that he or she may suffer other serious harm upon removal to that country, end quote. Don't forget about humanitarian asylum, particularly when an IJ finds past persecution on account of a protected ground, as occurred here. But in this case, the IJ denied that too. It did so on the ground that Mr. Muchiri failed to show the required severity of past harm or a reasonable possibility of other serious harm to warrant humanitarian asylum. The IJ further explained that even if Mr. Muchiri were eligible for asylum and humanitarian asylum, he would have been denied such relief on discretionary grounds due to his past encounters with law enforcement in the United States. Based on all this, the immigration judge denied withholding of removal as well. The BIA affirmed and then denied a motion to reconsider. The BIA actually ultimately granted that, only to dismiss the appeal again. Seems the BIA erred apparently in finding that Mr. Muchiri had only been harmed by his father because the record also showed harm from others in the Mungiki movement, but that all of it happened when Mr. Muchiri was a child, so still fundamental change in all of that reasoned the BIA to deny. Everything else was also affirmed by the BIA. All of it's now before the First Circuit, and the First Circuit sent it back. Counsel asserted quite a lot of errors, and mercifully to me, the First Circuit sees there as being one common contention. Quote, the BIA failed to address his claim that he reasonably feared future persecution by Kenyan government officials on account of either his family status or his ethnicity. End quote. The BIA appears to have overlooked the arguments, explains the First Circuit. Maybe it declined to consider them because Mr. Muchiri didn't develop them enough below, maybe. But the BIA didn't say. To the court, Mr. Muchiri brought up arguments related to family status and ethnicity in his affidavit and testified similarly before the IJ. And the First Circuit sees sufficient arguments to the BIA all about this stuff. It's pretty fact-specific, but to the court, it's there. Comb your record on appeal, folks. It's really the only way to do it. So too in the motion to reconsider. It wasn't just about abuse by the father and family members as a child. In the alternative, Oil seemed to argue, at least to the panel, that the BIA touched on it all sufficiently when it reviewed Kenyan country conditions and deemed those conditions lacking for an asylum withholding and CAT grant. But that country condition discussion is not specific enough to whether Mr. Muchuri reasonably fears future persecution based on being presumed to be Mungiki due to either his family or ethnic status, explains the First Circuit. And to the extent there's other evidence supporting a denial, well, the BIA didn't discuss it at all, so the First Circuit's not going to let Oil rely on it. Some other stuff too, but at the end of the day, the court sees a record where the BIA has done a bad job explaining itself. So it sent the case back. Hard to survive a petition for review when you run into the New England dream team of Chelsea Eddy, with whom Jill Bissonnette and Sang-Yup Kim are involved, all from the ACLU New Hampshire. Congrats particularly to Chelsea, who I believe was listed as lead from ACLU New Hampshire for the first time on a precedential decision. Could be wrong. Either way, congratulations. Astute listeners will recall that Sang-Yup often gives me some more insights on these cases when he's involved, and so among other things, he writes this. Writes Sang-Yup, this is a rare case in which the First Circuit revisited its stay denial, a pro se stay motion, and granted the stay after ACLU intervened and filed a motion to reconsider. Because of this stay grant, the petitioner was able to receive a bond hearing and was released. Thanks for letting me know, Sang-Yup, and thank you for all the very important work that ACLU is doing in New Hampshire and around the country. Thank God for the ACLU, folks. And that is Muchuri v. Blanche. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.